Sir,
Oh,
I'd
you
like to
shut the
thank.
fuck up and let me
I'd like.
talk for a moment.
Hey, don't speak that
No
way in
way.
court.
What are you gonna do? Throw me in jail?
Hey everybody, major apologies for the absolutely terrible audio and video quality here. I've recently switched to a different computer, and where I am right now, I forgot my microphone. So yeah, I just wanted to bring you this one. This one comes from old Squishy Gardner, the OG. This is unbelievable. This guy is painful, but I hope you guys enjoy it. He gets pretty heated.
You're out now motioning for a special prosecutor because even prosecutor Christopher Eastwood said he's out for my blood.
Okay, next matter is number 6 on the calendar, Daryl McWilliams.
Good morning, Your Honor.
Good morning, Mr. McWilliams. Let me go ahead and pull up your case in the
I
computer.
apologize for being in bed. I'm not feeling well, but I'm here with a good appearance in the background. So
Okay,
Too,
well,
I'm in
it's not inappropriate, so that's fine.
Okay. Did you receive my motions to dismiss both cases? First question.
It's right off the bat. He's filed a motion for dismissal. Yeah.
I believe I've got a copy of that in the file. Let me go ahead and pull up some papers here from the court file. One moment.
Yeah, there should be 2 cases on today. And they both have motions for dismissal and all that filed into them.
Do we have 2 cases on for? Oh yeah, I see. Number 6 and 7. Okay, got it.
Yeah, you should have 5A0490039 and 5A0424973.
Okay, I do see your motion to globalize and to dismiss.
Yeah,
Please stand by while I take a chance to look that over.
go ahead.
Okay, Mr. McWilliams, I have reviewed your motions, and your motion to dismiss the cases against you is denied. Do you have any other argument?
Yes, I would like to set this matter over because there's a case currently ongoing, and I will cite that for you. It's Master Sergeant Charles Fields, my father, case number 252012920-08 in the Superior Court. It has jurisdictional authority over this matter. It is currently handling ex parte motions of stay of relief. I also have other criminal cases where I have an attorney who's motioning the constitutionality of the order plus getting a sound expert. I would ask to defer today's hearing to a later date to allow those motions and orders of Superior Court to proceed and allow my attorney the opportunity to have the prosecutor removed as well as argue the constitutionality of the legal ordinance modification. Just so you know, Your Honor, I responsibly in the beginning of the year took accountability for a charge of playing music because I DJ, and a prosecutorial agreement was made. And then suddenly, months later, they illegally modified the law without applying to the Department of Ecology pursuant to RCW. So there's a lot of moving parts right now. And rather than argue today or bring witnesses, if you're going to deny my order on the face of, I would ask that you allow the Superior Court time for the case that I cited to make a ruling over its jurisdiction in this matter, also allowing my time for my criminal attorney to finish her filings so that I may copy and apply them into this case as they have revolving facts and similarities as well as a question of the constitutionality of the law. So I would ask that this, based on her presumption that the constitutionality argument will take 1 to 2 weeks to get in and then heard, I would ask that this be set over for a month, at which point I will bring witnesses and I will supply the court with more evidence, including any other filings or orders that the Superior Court chooses to dismiss this on the merits of which we motioned.
So I do.
And the award for the longest sentence in the history of humanity goes to this guy. I'm guessing that the sound complaint wasn't actually his music, but just him being a general whingy bitch.
find that both of the cases that are pending on this morning's docket were filed and notice was mailed. Well, in one case earlier in September, and in the other case was filed towards the end of September, and the notice was mailed on October 1st.
Yes, but there's been an
It,
ongoing barrage of
it's
police abuse.
sir, I'm speaking. It's currently December 10th. I do find that that's adequate time for you to have prepared your defense. I also
I,
noticed that your attorney is not appearing on your behalf today. You may have an attorney in other cases, but it appears you don't have counsel in this case. I've considered the argument that you've raised, and I'd like to, at this point in time, uh, understand if I'd like to hear if you have any further argument or testimony that you'd like to offer.
yes, the citations that are before you lack police training because they were reading in DBC and not DBA, and the law is specifically cited as DBA as the measurement, as my expert witness will testify as well. So the two citations before you today, sir, were unlawfully measured in DBC and not accurately in DBA. Myself, Charles Fields, and Logan Fields, who I can get mustered up right now for testimony, were there when we tested sound decibels, and we have a scientific measurement. I master all my sounds through a software called Platinum Notes. So they're all measured to negative 11.5 decibels. So when the board is set for sound, each song is exactly the same. And I've also built a $7,000 acoustic wall since the first charge. I've taken steps and liberties to ensure that I'm not a disturbance. However, the cases before you in these two violation codes, I believe one of them was for violating the decibel readings. However, the officers have already admitted on camera to me and on the record that they were reading in DBC, which is a different compression and more sensitive and not reflective, as the law states, of DBA. And I believe the second one was for motor vehicle noises or sirens and horns, which doesn't apply to this situation. So it's a illegal law that doesn't apply to what was going on. Unless I'm standing wrong, there's a lot of them. These both could be the ones where they just read in DBC. So, with that said, we have a problem because the law states DBA. So, the ones before you, I believe, are unconstitutional and inaccurate based on the evidence. But I am a disabled, vulnerable adult, and I've been subjected to violent crimes and abuses over the past 60 days. There are multiple protection orders granted for me as a vulnerable adult. That's why I would justify to you, Your Honor, the continuance based on the special circumstances, not your review of the calendar. But I'm happy to cite every case right now to you to show you that I've been busy protecting me and the custodial rights of my minor children and my adopted adult, vulnerable adult son, Logan Fields, who also participates in the music. The music is for therapy purposes, of which my doctors will testify. I made a prosecutorial agreement and I stayed within those sound decibels, but unfortunately, the officers in the beginning were reading them in DBC. Even Officer Yeager himself shows his DBC reader beside mine in a video, which I didn't have time to get before you because my life has been in danger. But in that video, he shows, oh man, we have been reading in DBC and not DBA, because showing even on my porch, I'm within those EDNA Class A residency levels, which is between 7 a.m. and 10 p.m. You could be 55 decibels and under. You can exceed decibel limits for 15, 10, and 5-minute segments by certain amounts of decibels. In this case, I would be testing scientific equipment like Serum 2 presets. Sometimes when you try a preset, it fires off louder out of the decibels when it's a DAW plugin, which is the digital audio workstation. So no effort or angle of any of my music has ever been meant to disturb or annoy anybody. But I do believe in the two citations you have that they were decibel reading oriented. And at that time in training, those officers were reading in DBC and not DBA. And I was following the prosecutorial agreement at all times. What we've run into to now is several more charges which are being challenged because after the prosecutorial deal, they then modified the law without applying to the Department of Ecology and made it where the neighbors have discretion. And since then, they've been abusing it up to 9 charges now. And I've had to get protective orders from them from trying to run me over with their truck. They're making threats against me. They're slandering and libeling me. There's an open civil case against them, as well as the Master Sergeant Fields versus City of Castle Rock. They have retained a really big law firm, and right now we have filed motions even today in court for ex parte to address this case among the other several noise violations. So I would ask, based on the evidence alone within your police report, that the officers lack training and knowledgeable understanding of decibel measurements, and we're not accurately reading and reflecting that. I know this because I volunteer a lot of my time with churches for LED walls, stage, and their concert developments. And for the audience, we have to keep it below 92 decibels for a certain amount of time exposure, or it could damage hearing. I'm very knowledgeable in measuring decibels, and I've taken every step to ensure to make sure I'm not violating the law since I first agreed to a prosecutorial deal in which I accepted guilt without even having an attorney. But now that the city has taken to egregious contact,
Jesus, man, take a breath. Holy shit. I know she was thinking the same thing as me. She was like, "Oh, for fuck. My God, I thought his last ramble was the longest sentence known to man. This isn't even over."
conduct, we are now motioning for a special prosecutor because even prosecutor Christopher Eastwood said he's out for my blood, and he said it in front of the mayor or the Grimm Law Group when they were representing me until a neighbor broke into my house and tried to assault me, and now the Grimm Law Group represents her. There's a lot of conflicting conflict and overlapping facts, and it all originates with the city and improper decibel readings, trainings, and legal modifications to the law. So while these things are ongoing, I would ask that if you read the police report, you'll notice that this is a decibel measurement training lacking, that they were coordinating at that time in the wrong measurements. Because any other time after that, once they went
Jesus.
from DBC to DBA, the officers acknowledged that I was within the sound limits. And I have what I call the cop line on my Flex 10. It's a DJ controller board, and I have it marked so that way I know I'm always within the decibel limits, even after installing a $7,000 acoustic wall. I've made every effort to make accommodations not only for my needs as a vulnerable adult defined by Washington state and federal laws to be able to play sound for therapy purposes, but I've tried to create a safe environment for my community. But the neighbors have taken to making false allegations that I have a gun and I'm pointing at them, and extreme egregious acts that I am a felon as a youth, a felon, and I cannot have guns. So I am objecting to these actions that are being done to me. So right now, there's kind of a lot of things revolving. That's why I asked in my motion to globalize the cases, because there's training aspects to address, there's laws and ordinances to address, and more importantly, there was no motor vehicles, sirens, horns, or anything like such taking place, like further citations. So I would ask this course dismiss this on the basis that the officers acknowledged that they were reading in the wrong decibel compression
Okay, thank
format.
you for summarizing your.
Yes, summarizing it is making it shorter. This was somehow 10 times longer. Oh my God. My brain hurts after that. I thought I could fucking talk. Jesus. Mother of God. Just so you know, this guy goes insane here at the end. Like, just, yeah.
Motion, Mr. McWilliams. Your motion to dismiss is denied based upon the evidence that is set forth in the officer's report on the case ending in 4973, as well as the case ending in 0039. The court does admit into evidence both of those officer reports, and based upon that evidence, I will find the violations committed on
Have you, before
in
you
case
say
number
that, have you find those
4973.
violations so I can
Sir,
appeal them?
sir, you absolutely can appeal my ruling.
Yeah,
There's
but give
no
me a
issue with that
reason
at
and
all.
don't be a
Uh,
baby about it.
no, don't, there's no issue, sir. There's
What
no
is
issue
this
with that
about?
at all. You contact the clerk's office. You can file your notice of appeal. On case number 4973, the violation amount is $103. And on the case ending in 0039, the violation amount is
So
$257.
what what
That'll be the
evidence?
court's order for today.
What
And
evidence are you citing as the basis against my actual legitimate legal motion? You're saying the
the
officers
evidence
that
is
are
what I
being
just the
sued.
evidence is what I just cited to, which is the officers' reports in both matters which the court has admitted into evidence. In
So
response to your question, that is the evidence
you're
against
taking
you.
sworn officers that are being sued in a federal lawsuit for face value when they've been targeting and attacking me, and you're
Yeah,
That
going to
constitutes
justify
the
it.
evidence against you today. That's going to be the court's order. This concludes your matters,
That's all right.
and
But wait, that takes as a
I'd like to thank
one-sided
you. I'd like
police
to thank you
statement.
for,
Oh,
sir. I'd
you
like to
shut the
thank you.
fuck up and let me
I'd like.
talk for a moment.
Hey, don't speak that
no
way in
What
court.
are
way.
you going to do? Throw me in jail?
Well, if you were here, it might be an
I bet
option,
you wish you could. You know what? Give me a real reason. A one-sided police
sir.
report.
Sir,
A
you're,
judge has even said a
sir. I don't
one-sided
want to
police
have to find
report
you in
is not
contempt.
evident.
Okay?
Find him
I
Am I
in
don't want to have to
being
contempt.
find you in
disabled and under
contempt.
Fuck this
duress?
guy.
This concludes your matter for today.
My First
You're
Amendment
free to
rights?
disconnect at this time.
Yeah, you're
Thank
a
you.
coward. You're a coward. You're a coward. Remember
Okay. Well,
I like this judge. He seems like a very nice guy, but grow a pair of nuts. That's like as contemptuous as you get. That's the definition of contempt. I saw a guy once get a $50 fine for not wearing a tie. I mean, yeah, that's as contemptuous as you get. I love the lady's reaction down below. That was absolutely hysterical. Anyway, let me know in the comment section what you think should have happened here. Again, sorry about the terrible audio. I have a backup mic, but I totally forgot to bring that. I need to put that in my bag and leave it there. But anyway, I hope you enjoyed it. Thank you, old Squishy Gardener, as always, and we'll catch you all in the next one. Slán